Welcome to the NC DWI Guy Podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NC DWI Guy, Jake Minick.
Hello, fellow freedom fighters, and welcome to another episode of the NC DWI Guy Podcast. Today is going to be a fun episode. We are going to look at attacking checkpoints, so spending some time on checkpoint issues and the constitutionality of a checkpoint. But before I get that, I have a pet peeve that I'd like to share. I was just reminded of this as I was about to start recording the podcast, but I will have some people, clients or, people that I've worked with in the community, friend, whoever it is, doesn't really make any difference what the relationship is, that will call me on the phone and then proceed to call me another 3 or 4 or 5 or 6 times in a row. They don't leave a voicemail. They just call, like 8 times in a row, back to back to back. That is super annoying. If you know anybody that does this, discourage them from doing this. This is just rude. So if you are going to call somebody and they don't answer the phone, leave a voicemail, send a message, send a text message afterwards, telling them what your concern or problem is, and then leave them alone. Let them call you back. Just wanted to get that out there, because every time that I hear that like second and third ring that comes in right after the first one, it gets under my skin. So help make the world a better place by discouraging the repeat callers. And just so everybody knows, I don't answer the phone. If you call that second and third time, I make it kind of a point not to respond. So if anybody's listening to this that is trying to contact me, that's one way for me to delay my call back to you, is that if you call like 3 or 4 or 5 times in a row and don't leave a voicemail and don't leave a text, I'm not calling that number back, just so you know. But to get into today's episode, and on a much more positive and exciting note, we're going to be talking today about checkpoints, DWI checkpoints. And this is a fun topic of conversation because it allows us to delve a little bit into the law. If you are interested in kind of taking some of the information from today and digesting it a little bit more, if you go to the firm's webpage, minicklaw.com/lawyers, there is a whole resource page there for attorneys. And you can go there to look at this particular issue, attacking a DWI checkpoint. You can find the memo that I'm about to read from. You can find the cases, links to the actual cases so that you can print them off and put them in your trial bag. You can find the statutes that we're going to go through. Read those cases. If you are going to make an argument based on the lack of constitutionality or the lack of statutory authority of a checkpoint, make sure that you are reading in detail the cases that are referenced. And again, we'll go through these in terms of the big picture of some of these landmark cases from North Carolina, but make sure that you are also doing your own independent research and study on these particular issues. In North Carolina, the thing that we want to start with anytime that we are attacking a checkpoint is the Constitution, the constitutionality of the checkpoint. And it's helpful when you're making an argument on a checkpoint to remember that as you are arguing the legitimacy of a checkpoint, even if you are not successful in attacking the checkpoint, you are putting into the judge's mind the illegitimacy of the entire investigation. So if you're attacking the checkpoint, but then also plan on substantively attacking at the guilt stage the DWI itself, actually going through not just the pretrial motion on the checkpoint, but through a full trial, really hammer the checkpoint. because now you are creating, even if the judge says this is a legitimate checkpoint, even if it's borderline, you are creating an illegitimacy about the investigation if the judge starts to see your points about the problems with the checkpoint. You're going to create a reason for the judge to want to find your client not guilty at the guilt stage of things. So it's important to attack the checkpoint in every way possible, even if you don't think that the judge is going to rule in your favor on the checkpoint. As long as there is a legitimate argument to be made there, you're doing yourself a service by attacking the legitimacy of the stop, by showing that this whole thing got going because of a unconstitutional, illegal checkpoint. And so that's where we want to start our checkpoint argument, is with the checkpoint analysis being constitutionally based. You always begin every attack of a checkpoint with the highest law in the land, the Constitution. As I start this episode every single time, hello, fellow freedom fighters. We're freedom fighters because we are fighting to protect the Constitution. The Fourth Amendment protects individuals against unreasonable searches and seizures. Start with the Constitution. Point to the constitutional Fourth Amendment. A traffic stop is a seizure, even though the purpose of the stop is limited and the resulting detention quite brief. That is from State versus Barnard. Again, all of these case references are in the article that can be found at our minick.com/lawyers page, but that is from State versus Barnard. A traffic stop is a seizure, even though the purpose of the stop is limited and the resulting detention quite brief. The United States Supreme Court has held that, quote, the principal protection of the Fourth Amendment rights at a checkpoint lies in appropriate limitations on the scope of the stop. That is from United States versus Martinez Huerte, a 1976 case. Argue to the judge that both federal and state courts have long held that a checkpoint, a stop without individualized suspicion of wrongdoing, is presumed to be unreasonable. Start there. It's presumed to be unreasonable. City of Indianapolis versus Edmond. It's presumed to be unreasonable. To be constitutionally valid, the checkpoint must, 1, have a legitimate primary programmatic purpose, and 2, be reasonable. So as to have a primary programmatic purpose that is legitimate, and it has to be reasonable. The touchstone of the Fourth Amendment is reasonableness. So that's always going to be an issue, but it also has to have a legitimate primary programmatic purpose, and that's where we're going to start, is with the primary programmatic purpose. If the checkpoint is reasonable but does not have a legitimate primary programmatic purpose, it's an illegal checkpoint. The Supreme Court has held that where the primary purpose of the checkpoint is ultimately indistinguishable from the general interest in crime control, the checkpoint violates the Fourth Amendment. That's from City of Indianapolis versus Edmond. To determine the primary programmatic purpose, a judge must consider all available evidence. See Ferguson versus the City of Charleston, a 2001 Supreme Court case. The primary purpose must be identified in a written checkpoint plan. The officer supervising the checkpoint must be able to testify about the primary programmatic purpose of the checkpoint. However, the state's asserted purpose for the checkpoint is not enough to establish a legitimate purpose. That, again, is from Ferguson versus City of Charleston. They also noted in that case, a trial court may not, quote, simply accept the state's invocation of a proper purpose, but rather carry out a close review of the scheme at issue. So you cannot just accept the state's, the officers, the primary officers' invocation of a proper purpose, the trial court must look at what's going on at the checkpoint. Avoiding a finding of general crime control is not achieved simply by asserting one legitimate purpose of the checkpoint. City of Indianapolis versus Edmonds said, quote, "If this were the case, law enforcement authorities would be able to establish checkpoints for virtually any purpose so long as they included a license or sobriety check," end quote. Surely an illegal multi-purpose checkpoint cannot be made legal by the simple device of assigning the primary purpose to one objective instead of another, especially since the change is unlikely to be reflected in any significant change in the magnitude of the intrusion suffered by the checkpoint detainee. That's from Lefebvre's Search and Seizure. So when you're looking at that primary programmatic purpose, you've got to look at, again, these U.S. Supreme Court cases. State versus Rose, a North Carolina case, also provides a great roadmap for the requirement that the state present evidence of a proper primary programmatic purpose. Proper primary programmatic purpose. That's a fun tongue twister too. If you wanna, have a fun time with your fellow criminal defense attorneys, you can see who can say that 4 times fast. But you always want to start with that constitutional analysis. And any time that you have a checkpoint hearing, if there are multiple officers that are involved, the officer that was the one that oversaw the checkpoint, as well as the boots on the ground, if there's multiple officers that are testifying, this is a really important time to ask the judge to sequester the state's witnesses, because it is very rare that there is a lot of briefing that goes on before a checkpoint, that there is a lot of planning that goes on before a checkpoint. And so the more you can show that the officers that were involved in the checkpoint are not on the same page, the better you're going to be. And if there's multiple officers that are not, that were not involved at every stage, or if there's multiple officers that were involved, if you separate those witnesses, you are likely going to hear a lot of different reasons this checkpoint was being conducted, a lot of different reasons as to why the location was chosen, which we're going to get into here in just a second in terms of reasonableness. But you're going to hear a lot of inconsistencies, and that just shows that the checkpoint is illegal, that it is haphazard, that it is random. That there was not the proper planning and not the proper execution, because there wasn't a opportunity for everybody to get on the same page as to why this checkpoint is being conducted and what the purpose of the checkpoint is. The primary programmatic purpose can't just be put into a document and then not communicated to the boots on the ground. You have to have the officers have a proper briefing in order for them to be carrying out that primary programmatic purpose in a meaningful way. So just documenting what the primary programmatic purpose is not enough. And if you get 2 officers that give different testimony about what the primary programmatic purpose is, that's going to create problems. That's going to create problems for the state in terms of being able to show the proper primary programmatic purpose. All right, so moving on to the second thing the state has to show, they have to show that the checkpoint was reasonable. So the Supreme Court has developed a 3-part balancing test to weigh the public's interest in the checkpoint against the individual's Fourth Amendment privacy interest. This is from Brown versus Texas, a 1979 U.S. Supreme Court case. Number 1, the gravity of the public concerns served by the seizure. Number 2, the degree to which the seizure advances the public interest. And finally, number 3, the severity of the interference with individual liberty. So in terms of number one, this is almost always going to be something that the state can show. So if the primary programmatic purpose of the checkpoint is legitimate, this prong of the reasonable test is going to probably be difficult to attack. The Supreme Court and the North Carolina courts have found that license and registration checkpoints and sobriety checkpoints advance an important purpose. So in terms of number one, the gravity of the public concerns served by the seizure, that's likely going to be met as long as there was a proper primary programmatic purpose. Number two, the degree to which the seizure advances the public interest. This is the first prong that you want to really have a good cross-examination prepared for in order to pull out whether the state has satisfied this second prong of the reasonableness test laid out by Brown versus Texas. The second prong of the three-part reasonableness test assesses how the police checkpoint has been appropriately tailored to fit its primary purpose. The court in Illinois versus Lidster, a 2004 Supreme Court case, talks about this. But in terms of North Carolina specific case law on this issue, we look at State versus Rose. And so State versus Rose identified several non-exclusive factors to consider in whether the state has met this second prong of the three-part reasonableness test. And that second prong, again, is the degree to which the seizure advances the public interest. So here are some of these non-exclusive factors to consider. Whether the police spontaneously decided to set the checkpoint up on a whim. That's likely going to be relatively easy to show. If it was set up the same day or called in, Highway Patrol seems to be the worst about this in terms of my experience of just calling into a supervisor, asking for permission to set up a checkpoint, receiving authorization basically either immediately, or I've even seen sometimes the next morning them getting like almost post checkpoint allowance for setting the checkpoint up, post checkpoint authorization. But whether the police spontaneously decided to set up a checkpoint, that's a big one. And that happens in a lot of checkpoints that I've seen. Spontaneous. Whether the police offered any reason why a particular road or stretch of road was chosen for the checkpoint. Ask that. Just ask, what was the particular, you can almost use the State versus Rose factors as your cross-examination. So at what point did you decide to set this checkpoint up? How long before the checkpoint? Was it decided that you guys were going to do a checkpoint that night? Do you know what the reason was that this particular stretch of road was used as the place or location of the checkpoint? Do you know why that was? Whether the checkpoint had a predetermined starting or ending time. I've seen checkpoint plans, State Highway Patrol, as well as other agencies that do not have a specific end time in the checkpoint. And that's important because that just means that then they could go on for 30 minutes or technically they could go on for 5 hours. There's no ending point. That's not appropriately tailored to fit the primary purpose of the checkpoint. Number three, whether the police offered any particular reason why the particular time span was selected. So again, just use that as your cross-examination question. Officer, I see that in your checkpoint plan, it looks like the starting time was 10 o'clock p.m. and the end time was midnight. What was the reason that you chose that particular time? And maybe there's a legitimate answer to that question. Maybe there's not. But the only way that you're going to know is by actually taking the time to ask that particular question. That's the only way that you're going to know the answer to whether or not that factor has been satisfied. So use the factors themselves as the template for your cross-examination, because then you can specifically show, Your Honor, my approach with State versus Rose, here's the factors as you just heard testified. None of these were met in this case. The officers didn't know why they had chosen a particular stretch of road, why this particular time was chosen. They indicated to you that they had, decided to put this checkpoint up 30 minutes beforehand, which that's on a whim, Judge. That's exactly what that means. So use those factors as the basis for your cross-examination. So finally, number 3, the third prong of the three-prong balancing test of reasonableness is the severity of the interference with individual liberty. So again, that's the third prong, the severity of the interference of the checkpoint with individual liberty. The final prong of Brown's 3-part reasonableness test focus on individual discretion of police officers that are conducting the checkpoint. The courts need, quote, to assure that an individual's reasonable expectation of privacy is not subject to arbitrary invasions solely at the unfettered discretion of officers in the field. The seizure must be carried out pursuant to a plan embodying explicit, neutral limitations on the conduct of individual officers, end quote. That's from Brown. Use that language. That language is killer. Use that language. The seizure must be carried out pursuant to a plan embodying explicit, neutral limitations on the conduct of individual officers. That's important. That's why getting the approval of your checkpoint plan the next morning, that's not going to eliminate individual discretion when the checkpoint has actually already occurred before you get the authority for it. Like this second prong, the courts have identified a number of non-exclusive factors to utilize in assessing the severity of the interference with individual liberty. State versus Veazey has this. You can find these, I think, also in State versus Rose as well. But these are some of the non-exclusive factors used to determine whether the third prong is legitimate. So here we go. Here are some of those factors. The checkpoint's potential interference with legitimate traffic. So is there an interference with legitimate traffic? Whether the police took steps to put drivers on notice of an approaching checkpoint. Did they use signs? Did they indicate that there is a checkpoint ahead? In Buncombe County, this is extremely rare. It does happen sometimes, but it is extremely rare for there to be signs indicating checkpoint ahead or DWI sobriety checkpoint ahead. It's extremely rare for them to use these signs. So you can just ask, was there signs that indicated that a checkpoint was ahead? Because if not, that's one factor against the state in terms of this particular prong. Whether the location of the checkpoint was selected by a supervising official rather than by officers in the field. Again, this factor many times is not going to be met. When you have a couple of highway patrol officers that call in to their supervisor and ask to do a checkpoint, they already know where that checkpoint is going to happen. They're just looking for the stamp of authority. So if it's individual officers that are conducting the checkpoint, not a supervising officer, again, another factor against the state. Whether the police stopped every vehicle that passed through the checkpoint or stopped vehicles pursuant to a set pattern. Now, if you have a written checkpoint plan, might be hard to show that they didn't do this because all they're going to just say is, here's what the written plan said, and we did what the written plan said. But if there's not a specific explanation in the plan about how vehicles are going to be stopped, if you have sequestered the witnesses, sequestered the officers that were involved in the checkpoint, you might be surprised what you hear in terms of the pattern of vehicles being stopped and the discrepancies between the patterns that are being communicated from the various officers that were involved. Whether the drivers could see visible signs of the officer's authority. So again, some of those are required. Blue lights being activated, maybe officers are wearing, specific vests or whatever it might be. But whether the drivers could see visible signs of the officer's authority, whether the police operated the checkpoint pursuant to any oral or written guidelines. So again, at this point, we're not even talking about the North Carolina statutory requirements. We're talking about the constitutional requirements of reasonableness. So was there any oral or written guidelines? the less guidelines that are in place specifically in terms of writing related to your checkpoint, the more unreasonable it is, because that means that there's going to be more individual officer discretion, because not everybody knows exactly what's supposed to happen because it's not in writing and it wasn't clearly communicated. Whether the officers were subject to any form of supervision. So is there a supervising officer that's kind of conducting the entire checkpoint? Does each individual officer just kind of have one lane of traffic that they're controlling, but there's nobody kind of really looking over their shoulder, so to speak? Whether the officers received permission from their supervising officer to conduct the checkpoint. Again, you would think that that would be a given, but surprisingly, I have seen that really be an issue in multiple checkpoint situations. So one thing to remember as you're going through these factors, as you're going through a analysis of a checkpoint, and this is maybe the rah-rah time of like, we should be taking more cases to trial as a bar, is that if you receive in evidence a written checkpoint plan, that does not mean that the checkpoint was constitutional. So if almost every checkpoint is going to appear valid on paper, and in discovery, that's oftentimes all that you're getting. So you look at that and you're thinking to yourself, well, the officers probably had a meeting about this, that here's what they're supposed to be doing in terms of the time and what's going on with the checkpoint. But when you do a hearing on a checkpoint, you will be surprised how many times there are big holes in terms of the state conducting a reasonable checkpoint as you begin to ask these questions during cross-examination. Because officers are not generally having their feet held to the fire on checkpoint issues. They think, hey, we did a plan, we wrote a plan out, we stopped some cars, we got a couple of speeding tickets issued to DWI, and we closed it down, right? That was the end of it. If there wasn't a lot of training and, again, briefing that went into this particular checkpoint, you're going to hear a lot of variance when you talk between one officer that's on the ground and another officer that's on the ground. So again, just because you receive a checkpoint plan as part of discovery doesn't mean there are not checkpoint issues to be fought. And really, a lot of times the only way to determine if the checkpoint was reasonable is to put it into a pretrial motion, have a hearing on it, and see what the officers say on the stand. A lot of times that's the only way to determine if a legitimate, constitutional, legal checkpoint happened, is to hold the state's feet to the fire and call the case for trial or for pretrial motions. There are also some statutory attacks to a checkpoint. If a checkpoint is constitutionally valid, it must still meet North Carolina statutory requirements for a checkpoint under North Carolina General Statute 20-16.3A, and then subsection kind of small a law enforcement conducting a checkpoint. A law enforcement conducting a checkpoint must, one, designate in advance the pattern for stopping vehicles and what type of information and documentation will be requested from drivers. 2, operate the checkpoint under a written checkpoint policy. And 3, have at least one law enforcement vehicle with blue lights on during the checkpoint. So there is a link to North Carolina General Statute 20-16.3A at minicklaw.com/lawyers, along with a number of other cases, statutes, constitutional sections at the lawyers page. In addition, there are a couple of other cases that are helpful In terms of North Carolina specific checkpoint cases, State versus Ashworth, which was a 2016 decision by the North Carolina Court of Appeals, and State versus Nolan, which is from 2011. Those are there at the lawyer's page. But in closing, what I would encourage you to do in terms of getting ready to attack a checkpoint is two things. First of all, I take that back. Three things. First of all, read these cases. Read the cases in full. Highlight them, make your own notes about them, make them yours, but read and know the cases. Number two, take cases to trial. Take cases to trial. The only way that you're going to see whether or not there was a constitutionally valid checkpoint is to take cases to trial. And then number three, organize your cross-examination questions in terms of attacking the reasonableness of the checkpoint. Organize your cross-examination questions primarily around the factors for the second and third prongs of the reasonableness balancing test from Brown versus Texas. Organize your cross-examination questions around the factors that are laid out in State versus Veazey and State versus Rose. Hope this has been a helpful podcast. Hopefully this is going to help you in your practice in terms of preparing a pretrial motion to suppress based on a lack of a constitutional stop, based on an illegal stop. And I look forward to talking with you next time. Hope you enjoyed today's episode of the podcast. If you did, please share the podcast with another freedom fighter in the criminal defense community, and be sure to leave us a rating on iTunes. See you next time.